Introduction. We began with Al-Mawardi's Ordinances of Government, which were written in an attempt to assert the authority of the Abbasid Caliphs. Al-Mawardi's treatise was intended as the theoretical basis for the delimitation of the spheres of authority between the Caliph, in charge of the religious affairs, and the Emir, in effective control of civil administration on the basis of a negotiated agreement. The treatise makes plain the specific character of the Islamic State as a religious political unity under the authority of Muslim law, which bound rulers and ruled alike. If the rulers wanted to stay in power, unchallenged and unhindered, they dared not ignore the fundamental principle that the authority conferred by the consensus of the Muslim community upon the lawful caliph was the only authority in law to which a Muslim would and could submit. Imamate. Al-Mawardi insists on the necessity of the Imam and by way of preamble states with the authority of the Quran, in quotes, the Imamate is established to replace prophecy in the defense of the faith and the administration of the world, end quote. Ijma is required to make the contract binding between the Ummah, which confers the Imamate, and the Imam who administers it. Next, Al-Mawardi asks whether the Imamate is demanded by reason or by religious law, and declares for the latter. His justification is derived from the Quran and is directed against the Mutazilites and against the philosophers influenced by Plato, Aristotle, and their Neoplatonic successors. The Imamate is established by a contract between two parties, the Imam and the Jam'ah. To be able to rule efficiently and to defend the faith, the Imam must satisfy 7 conditions, and the first of these is Adala, justice, since his primary function is the administration of justice. Next, he must possess ilm, knowledge of tradition enabling him to make independent decisions and pass judgment on point of law, ijtihad, in brackets. In practice, this was the task of the mujtahids, the professional jurists, and their successors, the muqallids. These later relied in their decisions entirely upon the predecessors instead of going back to the sources of law. The caliph must be physically and mentally fit to discharge all his duties as a ruler, and he must possess courage and determination to protect the territory of Islam and wage holy war against its enemies and against the infidels. He must also be a descendant of the Quraysh. The principle of election of the caliph. There are 2 forms of caliphal succession, by election or by designation. Faced with the need to justify 2 forms of caliphal succession, either by election or by designation, jurists had to lean on the historians, who were no more expert in constitutional theory than they themselves were skilled in historical criticism. However, the principle of the election of a caliph is thus based on the historian's description of the choice of Abu Bakr by 5 companions of Muhammad and of the choice of Usman after Umar had laid a charge on 6, including Usman himself, to elect one among their number as his successor. This choice had to be confirmed by the people. In technical terms, this means that election takes place by bay'ah, investiture, with the elector's oath of loyalty, to be followed by bay'ah in public, expressing the ijma of the community. If a choice had to be made between 2 candidates, the electors were guided by the circumstances of the time. political unrest, or external danger tipped the scales in favor of courage and determination. Otherwise, a learned candidate was preferred who was better able to guard the community against heresy and error. The foremost duty of the Caliph as the defender of the faith. The duties of the commander of the faithful naturally derive from the conditions he must fulfill. Once elected and invested, the Caliph binds himself to the Jam'ah by contract, ahad, guaranteeing loyal fulfillment of his duties and receiving in exchange a binding promise of obedience. The contract can be concluded only after the investiture, bay'ah, by the people with power to bind and to loosen. He cannot be replaced even by a man more worthy than himself, unless he forfeits the imamate by loss of freedom. This can come about in either of two ways. He may be made prisoner and thus unable to exercise his functions, or the seizure of effective power by an emir may place him under restraint. In the latter case, the preferable candidate must appear on the scene after the investiture, bay'ah, and the conclusion of the contract, ahad, between imam and jam'ah have taken place. It is not impossible that behind the terms preferred and preferable there is concealed the struggle between a lawful imam and a pretender who contests the caliphal dignity. This pretender may already be an emir or sultan. If it were to come to an open struggle and the pretender were to win, the lawful caliph would either be made prisoner or placed under restraint, and he would consequently forfeit his dignity. In such a contingency, the usurper must be recognized. Here, theory is made to suit an existing political emergency, which can only be terminated by legalizing usurpation. We have noted that there are differences of opinion as to how the office of caliph or imam is obtained. Apart from election, a caliph can be chosen and invested as the result of his designation by the reigning caliph. This is expressed by the term ahad, and the designated successor is styled here presumptive, wali al-ahad. This type of succession is again justified by historical precedent, but this time without scriptural warrant. Al-Mawardi adduces two examples from the early period of Islam. Abu Bakr's designation of Umar, accepted by the Muslim Jam'ah, and Usman's succession to Umar. The second example is strange, since Umar's appointment of 6 companions who were the consult with each other to choose one of their number as his successor is usually claimed to constitute an election, not a designation. These two acts serve Al-Mawardi as precedents to legalize the hereditary transfer of the dignity of Imam within the Abbasid dynasty, whose interest he promoted. The precedents were valid because they were set by the first two of the 4 Khulafai Rashidin, rightly guided caliphs, who were universally acclaimed as shining examples of the ideal Muslim ruler. Al-Mawardi discusses frankly and fairly the different opinions of the jurists on whether or not the caliph is entitled to designate one of his sons or relations as his successor, and whether he acts legally in doing so. This difference of opinion reflects different attitudes to the institution of the caliph and to its nature. Those who recognize the absolute authority of the caliph as head of the Muslim nation naturally concede him the right in his capacity as ruler to appoint a successor. Those who do not recognize his authority as absolute justify their opposition by declaring that family considerations must not weigh the caliph, who is bound by law to choose one who fulfills the conditions laid down for the holder of the office of Imam. He is clearly under the law and his authority subordinate to that of the law. In theory, they are certainly right. Others concede the reigning caliph the right to designate his father but not his son. All other relations are counted as non-kinsmen for this purpose. The safeguards which Al-Mawardi stipulates, such as the consent of the person designated as successor and his compliance with the required qualifications for the office of Imam, are purely theoretical and merely serve further to clothe hereditary succession with the mantle of legality. The principle of election is explicitly affirmed in the case of a caliph who chooses two heirs without assigning priority to one of them. After his death, the electors must exercise their prerogative and choose one of them. As historical precedent, Umar's charge to the companions to elect a successor is again quoted. We see from this example that Umar's action can be used for both types, election and designation, although in the later case the choice between more than one candidate is left undecided. It seems that Al-Mawardi favored election proper. The electors can act only after the caliph's death. During his lifetime, his authorization is required unless he is no longer in effective control. In this case, a situation has arisen which is equivalent to his death. Of equal interest and importance is the general contention that once the caliph has died and one of his heirs presumptive has succeeded him, the new caliph is free to appoint his own successors by designation. Duties of the caliph. Al-Mawardi assigns 10 principal duties of public concern to the caliph. The first is to guard the faith based on its established principles and on the consensus ijma of the first Muslims, Salaf al-Ummah. This condition presupposes the quality of ilm to be understood as expert knowledge of the tenets and traditions of Islam and the ability to expound and defend them against heretics. That this duty heads the list is indicative of the emphasis the Abbasids laid on the spiritual side of their office. Next, he must execute and preserve justice in conformity with his own adala, that is to say, he should have a good character and be just, honorable and right-minded. Defense of the territory of Islam, protection of life and limb, and guarantee of livelihood of the Muslims comes third, reflecting the qualification of kifaya or the satisfaction of all the requirements of the material side of his office. Fourthly, he is obliged to see the punishment for offences is meted out in accordance with the prohibitions of Allah and that the rights of his subjects are upheld. From the realm of justice, we move to that of military action, the garrisoning of frontiers and especially the waging of jihad against those who have been invited to accept Islam but have refused, until they have either been converted or have accepted the status of protected non-Muslims as dhimmis. From here we are to proceed to the religious obligations of the faith, the just distribution of booty from the jihad and of the sadaqah, the giving of alms, charity. This is followed by the responsibility for sound financial administration and for the judicious selection of competent loyal officials. Lastly, the Caliph is enjoined to extend his personal supervision to public affairs and to apply himself to the government of the nation and to the defense of the religion. It is evident that these 10 qualities, these 10 duties, are all religious, being directly related to God and likened to a walking in the path of Allah. Although they are divided into religious duties in the narrow sense and judicial, administrative, financial, and military duties, they are all complementary and all derived from the divine institution of the office of Khalifa or Imam. They show quite clearly the unity of religion and politics, of the spiritual and temporal, or religious and secular aspects of a life centered in and leading to God.